Understanding warranty obligations when a customer has defaulted on payment requires careful consideration. While the specifics can vary significantly depending on the jurisdiction and the exact terms of the warranty, there are some general principles to keep in mind. It's important to recognize that this information is not legal advice, and consulting with a qualified attorney is always recommended for specific situations. Firstly, let's define a warranty. A warranty is a guarantee or promise made by a seller or manufacturer concerning the quality, condition, or performance of a product or service. It's a contractual agreement that creates certain rights and responsibilities for both the warrantor and the warranty. Warranties can be express or implied. An express warranty is a written or oral statement about the product or service. An implied warranty is one that is imposed by law, even if it's not explicitly stated. Common types of implied warranties include the warranty of merchantability, which means the product is fit for its ordinary purpose, and the warranty of fitness for a particular purpose, which arises when the seller knows the buyer is relying on their expertise to select a suitable product. Now, let's consider the impact of a customer's payment default on the warranty. The central question is whether the customer's failure to pay releases you from your obligations under the warranty. The answer often depends on the specific language of the warranty agreement. Most well-drafted warranties will address the issue of non-payment. They may state that the warranty is void or suspended if the customer is in default of their payment obligations. If the warranty agreement contains such a clause, it's generally enforceable, provided it's clear and conspicuous. However, if the warranty agreement is silent on the issue of non-payment, the situation becomes more complex. In that case, courts may look to other factors, such as the applicable state law and the overall fairness of the situation. Some states have consumer protection laws that may restrict the ability of a seller to deny warranty coverage based on non-payment, especially if the amount owed is relatively small compared to the cost of the repair. It's also important to consider the concept of material breach. A material breach of contract is a failure to perform a contractual obligation that is so significant that it justifies the other party in terminating the contract. In the context of a warranty, the question is whether the customer's failure to pay is a material breach that excuses you from your obligations under the warranty. The answer to this question depends on the specific facts and circumstances. Factors that courts may consider include the amount of the unpaid balance, the length of the delay in payment, and the customer's reasons for non-payment. Even if the customer's non-payment constitutes a material breach, you may still have a duty to provide notice and an opportunity to cure the default before denying warranty coverage. This means you should inform the customer in writing that they are in default of their payment obligations and give them a reasonable time to bring their account current. If the customer fails to cure the default within the specified time, you may then be justified in denying warranty coverage. Another important consideration is the potential for counterclaims. Even if you are legally justified in denying warranty coverage based on the customer's non-payment, the customer may still have a valid claim against you for breach of contract or breach of warranty. For example, if the product or service was defective or not as represented, the customer may be entitled to damages regardless of whether they have fully paid for it. In some cases, the customer may be able to offset the amount they owe against the damages they have suffered as a result of the breach of warranty. Furthermore, consider the state laws. Some states have specific laws that govern warranties and consumer rights. These laws may provide additional protections to consumers, even if they are in default of their payment obligations. For example, some states have lemon laws that provide remedies to consumers who purchase defective vehicles. These laws may apply even if the consumer has not fully paid for the vehicle. To mitigate the risk of disputes over warranty coverage, it's essential to have a clear and well-drafted warranty agreement. The warranty agreement should specify the scope of the warranty, the duration of the warranty, any exclusions or limitations on coverage, and the procedures for making a claim. It should also address the issue of non-payment and state clearly whether the warranty is void or suspended if the customer is in default of their payment obligations. It's also important to maintain good records of all transactions with customers, including invoices, payment records, and warranty claims. These records can be valuable evidence in the event of a dispute. If you are considering denying warranty coverage based on a customer's non-payment, it's always a good idea to consult with an attorney. An attorney can review the specific facts and circumstances of your case, advise you on your legal rights and obligations, and help you make an informed decision about how to proceed. Now let us discuss the practical considerations. Even if you are legally justified in denying warranty coverage, there may be practical considerations that weigh in favor of honoring the warranty. For example, if the cost of the repair is relatively small, it may be worth honoring the warranty to maintain good customer relations and avoid negative publicity. On the other hand, if the cost of the repair is significant, or if the customer has a history of non-payment, you may be more inclined to deny warranty coverage. It's also important to consider the potential impact on your reputation. In today's world of social media, negative reviews can spread quickly and damage your business. If you deny warranty coverage to a customer, they may post negative reviews online, which could deter other customers from doing business with you. In some cases, it may be worth honoring the warranty, even if you are not legally obligated to do so, to avoid negative publicity and maintain a positive reputation. When dealing with a customer who has defaulted on payment, it's important to communicate clearly and professionally. Explain to the customer why you are considering denying warranty coverage and give them an opportunity to explain their situation. If possible, try to work out a payment plan or other arrangement that will allow them to bring their account current. If you are unable to reach an agreement with the customer, be sure to document all communications and keep a record of the reasons for your decision. Now consider the alternative dispute resolution. If you are unable to resolve a warranty dispute with a customer through negotiation, you may want to consider alternative dispute resolution methods such as mediation or arbitration. Mediation is a process in which a neutral third party helps the parties to reach a settlement. Arbitration is a process in which a neutral third party hears evidence and makes a binding decision. Alternative dispute resolution methods can be less expensive and time-consuming than litigation. It is important to consider the implications for future business. How you handle a warranty claim with a defaulting customer can have a significant impact on your future business. If you treat the customer fairly and respectfully, even if you ultimately deny warranty coverage, they may be more likely to do business with you again in the future. On the other hand, if you treat the customer poorly, they may be less likely to do business with you again and may even tell others about the negative experience. In addition to the specific legal and practical considerations, there are also some general principles of good business practice that you should keep in mind. Be honest and transparent in your dealings with customers. Don't try to hide behind fine print or mislead customers about the scope of the warranty. Treat all customers with respect, even those who are in default of their payment obligations. Try to find a solution that is fair to both you and the customer. Remember that your reputation is your most valuable asset. Do everything you can to protect it. In summary, when dealing with a warranty claim from a customer who has defaulted on payment, it's important to consider the specific language of the warranty agreement, the applicable state law, the potential for counterclaims, the practical considerations, and the impact on your reputation. It's always a good idea to consult with an attorney before making a decision. Finally, let's emphasize the importance of seeking legal counsel. The information provided here is for general informational purposes only and does not constitute legal advice. The law is constantly evolving, and the specific rules and regulations that apply to your situation may vary depending on your jurisdiction. It is essential to consult with a qualified attorney who can review the specific facts and circumstances of your case and advise you on your legal rights and obligations. An attorney can help you understand the terms of the warranty agreement, assess the potential risks and liabilities, and develop a strategy for resolving the dispute. They can also represent you in court if necessary. By seeking legal counsel, you can protect your business interests and ensure that you are complying with all applicable laws and regulations. Navigating warranty obligations when customers default on payments can be challenging, but by understanding the legal principles involved and seeking professional advice, you can minimize your risks and protect your business. Always prioritize clear communication, documentation, and a commitment to fair business practices.